in my job, I'm responsible for basically conducting, organizing, and processing all of the elections that our agency does. We do approximately 120 elections a year as jurisdiction over not only the state employees, but we also have city, county, school district, special districts like PUDs, ports. All public employees within the state are who have collective bargaining rights are under our jurisdiction. But since we're only talking to state employees here, this particular presentation will be limited to that. Okay, let's start again. All right. So, in order for employees to, state employees to have, hello. This is not working the way it should. All right. We'll see here. Okay. In order for employees to have collective bargaining rights under Chapter 4180, which is the Personnel System Reform Act of 2002, you have to be covered by civil service, 4106 RCW. WMS employees and exempt employees do not have collective bargaining rights, and they cannot be in a bargaining unit, okay? So just really quick, by a show of hands, if you know, how many people here are covered by the civil service law? Okay, and how many WMS employees do we have in the room? Okay, so all of the people who raised their hands who are WMS, you cannot be organized. Wow. All right. Chapter 391.25 WAC governs our processes for representation cases. Let's see if this will work. There we go. So, taking things as we normally get them, because the statute and the laws that created DES is a very, very unique thing. We have never seen it in our history at PERC. So we're kind of a bit in the dark as to how some of this is going to happen. So what I'm going to be explaining here is how representation cases normally come to PERC. Generally, our involvement in a representation case starts with the filing of a petition. Okay? Any petition that is filed with us by, for example, a union who wants to organize a bargaining unit of employees has to be accompanied by a showing of interest. So, what is the showing of interest? Showing of interest are individual cards that demonstrate an employee's desire to select, change, or remove a particular labor organization as its bargaining representative. Showing of interest cards must be signed and dated, and the showing of interest card must clearly state what is the purpose of the card. One of the things that I've learned since I started doing the election cases for the commission is that different organizations have different names for their cards. We call them showing of interest cards generally. For example, the Washington Federation of State Employees refers to them as green cards because they're green. But regardless of what the individual unions call their cards, cards have to, again, explicitly say what the purpose of the card is. I want to be represented by X union for purposes of collective bargaining. I no longer want X union to represent me for purposes of collective bargaining. It just depends on what the purpose of the card is. A card that asks for PERC to conduct an election is not sufficient. That does not demonstrate an employee's particular intent. Showing of interest cards are valid for 1 year within the date of the petition. So, if you signed a card 2 years ago and that's submitted with a petition, we'll look at the date and compare the date to the signing, and we'll reject that card for purposes of starting the election process. And showing of interest cards are kept confidential. So we keep those cards under lock and key. And one of the things that I often wind up having to explain to people who are trying to begin showing of interest who are trying to begin representation cases is when you submit your case filing, you only submit the showing of interest to us. You don't submit it, you don't give a copy to the employer. If you were decertifying your union, you don't give a copy of those cards to the union. You only submit those cards with us so we can keep the information confidential. Okay. Once a showing of interest card has been submitted to PERC to start an election or of any sort, those cards are kept with us forever. Okay? You cannot call us up and ask us to revoke a card that you had previously signed. Okay? The card starts the process. Now you'll notice a little asterisk here because there's a slight twist on that rule that I'll get to later, but it's something that occurs later on in the process, so I don't want to cover it now. But just keep that in mind. So once the case is filed, PERC sends a letter to the employer asking the employer for a list of employees that are going to be in the proposed bargaining unit. Okay? PERC also sends notices to the employer to post in their workplace informing employees that a representation case has begun. Now those postings will include a copy of the petition, so whoever wants to read those postings will be able to see what the union is petitioning for generally, okay? So these postings have to go wherever postings normally go. So you see those or Department of Labor postings that are often in like break rooms and places like that. We require the employer to post those in places where employees normally are, okay? So an employer can't hide the posting, on the back of a door, which we've actually had happen in certain instances. So, and again, these postings are designed to inform the employees of what's going on. We also ask the employer to furnish a list of the employees who are going to be in the proposed bargaining unit, along with an organizational chart. This org chart and employee list is really important for PERC because that's the beginning of how we determine whether or not the petition for a unit is appropriate. Okay. So, once we receive the list of employees from the employer, we then check the names on the employer's list against the names on the cards, the showing of interest cards that were submitted, okay? If at least 30% of the employees when comparing the two lists, if at least 30% of the employees on the list provided by the employer have signed cards, then we can actually move forward with an election. If the petition is not properly supported, we send out what we call a deficiency notice to the petitioner and inform them that they have 14 days to get more cards, demonstrating that they have more, that they can get the requisite 30% showing of interest. If they don't get the 30% within those 14 days, the case is dismissed. Other unions have a right to intervene in the proceeding, okay? So, say like an organization has filed with PERC a representation petition for, let's just say, the secretaries, okay? And we get the list of them, and we determine that, yeah, it's supported by 30%. A second union can get, all they have to do is get a 10% showing from that same group of employees in order to get their name on the ballot. So, and believe it or not, this happens more often than you would think. We often, a lot of the times, have elections where there are multiple unions on a ballot. In fact, I just did one, what was it, 2 weeks ago, where we had 3 different unions on the ballot, all going after the same group of employees out in Yakima County. In cases where it's a decertification petition, which again is which would be a petition to get rid of your union, the incumbent union is always on the ballot no matter what. They don't have to file a showing of interest. So, the petition's been filed. We have the list of employees from the employer. We've checked the showing of interest to make sure that the petition's properly supported. The next step in the process is where PERC will set up what we call an investigation conference with the petitioning union and the employer to get a whole bunch of issues done. I, as the representation case administrator, will be the one who conducts that phone conference. It's always by phone. And we ask the parties to stipulate to certain issues. A lot of these are really mundane, but they're important. You know, does PERC have jurisdiction? Well, pretty much with all state agencies, yes, we are. Are the names and addresses on the petition correct? You know, pretty simple. Is the labor organization qualified within the meaning of the statute? In order for an organization to appear to represent employees, we require that their primary purpose be for representing employees for the purposes of collective bargaining. That doesn't mean that has to be their only purpose, but it must be their primary purpose. Is the petition filed in a timely manner? Okay. Petitions can only be filed in certain times. I'll actually have a slide later on where I will explain those. Are there any blocking charges that could improperly affect the representation proceeding? A blocking charge would be where someone has filed an unfair labor practice alleging that one of the two parties has done something that would unreasonably affect the employee's choice. The classic one from the early days was a union would file a petition to represent a group of employees, and in retaliation, the employer would cut everybody's salary by 30%. We haven't seen one of those for a long time, but back in the early days, that was actually something that would routinely happen. And because the employer has decided to slash the salaries in response to an unfair labor practice, you know, that's going to impact how employees vote. Oh, you know, we desire union representation, you're going to cut our pay. So anyway, that's a blocking charge. These last two questions are the two most important questions, though, for the investigation conference. What is the appropriate bargaining unit? And an appropriate bargaining unit under 4180 is one where the duties, skills, and working conditions of the petitioned for employees have a significant amount of commonality that makes them an identifiable group, okay? That's, the standard, however, is very, very squishy. And I'll give you some examples here. PERC would find if a union attempted to organize every single employee within DES, all of them, all the eligible represented employees, if that was what the petition for unit is, PERC would probably find that appropriate. It's what we call a wall-to-wall unit. It's all the employees, okay? But there can be other subgroups, and I'll use a couple of examples here. All the IT employees, that's an identifiable group. You can have identifiable groups that are both horizontal. For example, all of the secretaries. Take all of the secretaries within a particular organization. That could be a unit. They also can be what we would call a vertical unit. And so, for example, an example of that would be if you have a particular program, and I'm trying to think of a good one here in state government that everybody might be aware of. Well, actually, I've got one. All of the employees under Jane Rushford, okay? She's external operations. That could potentially, all of those under her, it's what we would call a vertical unit because it's one common operation, okay? But again, what is and what is an appropriate unit is very squishy, and it's always done on a case-by-case basis. One of the things that, and this is the part that a lot of people get a bit confused on, and they get, this is where PERC gets a lot of questions and phone calls from. If the employer and union agree that the petition for unit is an appropriate bargaining unit, PERC will only give a cursory view of the unit to make sure that it looks appropriate on its face. We will not go diving in to make sure that, to really do a detailed examination. If the parties are willing to live with it, generally we're willing to live with it. And that gets people a little bit confused sometimes. It's like, well, I have nothing in common with this other employee who is part of the same bargaining unit, so how can this be appropriate? Well, the parties agree. So, that's, and that happens a lot. Again, I get phone calls all the time from people going, well, I have nothing in common with these people. Well, the employer was fine with the unit as is, and so we took it. So after after we get stipulations regarding the unit, we then look to see who are the eligible voters. And what PERC will do is we'll have that list of employees from the employer, and the employer will often try to challenge certain employees' eligibility to be in the unit based on two distinct standards. One is supervisors, and the other is confidentials, okay? It is inappropriate to mix supervisory employees with non-supervisory employees. Supervisory employees have collective bargaining rights, but they have to be in a separate bargaining unit from other employees. Now, one of the tricks that often happens with supervisors, though, is that there's a difference between supervisory employees and the lead employees. And lead employees are usually in the non-supervisory bargaining unit. Again, this is another one of those situations where people get a bit confused. Why am I in the same bargaining unit as my lead? Or, you know, this is the person who supervises me. Well, a lot of the times for our purposes, the person isn't actually a supervisor, it's a lead. Confidential employees is a little more nuanced. When we talk about confidential employees being excluded from bargaining units, we're talking about those employees who assist the employer in formulating its labor relations strategy. Okay? It's not an employee who has access to just the confidential material. There has to be that nexus that the employee assists the employer in formulating the labor relations strategy. Okay? Merely having access to the employer's labor relations strategy is not enough. Okay, we get that one a lot too. Well, my secretary has access to my files. Well, does she assist you in costing out a bargaining proposal, or is she at the table with you in negotiations? Oh no, not at all. Well, then she's probably not a confidential employee. So, if the unit is deemed appropriate and the number of eligibility challenges is small enough, PERC will conduct either an election or a cross-check. If the employees have elected union representation, after the election we will resolve the eligibility issues. If the parties challenge the appropriateness of the unit, or there's a large enough number of eligibility challenges that could impact the election, then we will hold the hearing first. And then, depending on the outcome of the hearing, we'll then move towards either the election or the cross-check. Once this investigation conference has occurred and all the parties' positions are made known, PERC will issue an investigation statement, okay? The employer is required to post this statement in its workplace, probably in the same place where we have them post the initial postings informing people of the process is beginning. Okay. The investigation statement will explain how the case will proceed. Okay. The investigation statement will also have attached to it a list of all of the employees who are going to be eligible to vote in the proposed unit. There are 3 outcomes that can happen. There can either be a mail ballot election, a cross-check of records, or a hearing to determine the appropriateness of the unit and the eligibility issues. So, mail ballot elections. Again, the investigation statement will state that a mail ballot election is going to occur. And when we do mail ballot elections, we have yet another posting that we put up in the workplace. And this is a nice big blue one. And it says Notice of Mail Ballot Election. And it states all of the terms for the mail ballot election. Ballots are out for no less than 14 days. If there was any time where we have elections in Eastern Washington, we always have the ballots out for 21 days. It's probably not going to be an issue here. When there's only one union on the ballot, the choice on the ballot is between the union and no representation. Okay? Again, and also when there's only one choice on the ballot, elections are decided by a majority of ballots cast. Okay? That standard right there is very important. We often get statements or calls from people saying, well, if I don't vote, isn't that just a no vote? No. Okay? So, really quick here. If there are 10 eligible voters in a bargaining unit and 7 of them vote, it only takes 4 votes for representation for the union to win and for a certification to be issued, bringing in a bargaining unit representative, okay? So, majority of ballots cast. Right? If there's a tie vote means that the employees have not conclusively demonstrated they want union representation, and no representation will be certified. So, again, if you have 10 employees, 8 of them vote, 4 vote in favor, 4 vote against, that will be a no representation vote. Okay? Can we hold the questions until the end? Thanks. Okay. So that was elections. CrossCheck of records. Okay? You may have also heard this referred to as a card check. We call it a cross-check. A cross-check of records is an administrative process where PERC compares the signatures on the showing of interest cards provided with the petition with signatures on employment records that are provided to PERC. Okay? So, if the petitioning union has submitted a showing of interest demonstrating that at least 50% of the employees in the proposed unit have signed cards favoring representation, we will do a cross-check of records as opposed to doing a mail ballot election. Okay, and again, 50%, and no election will occur. Now, so what we wind up doing when we actually do a cross-check is we will look at the signature that's on the card, and we will look at the signature that's on the employment record. And if they reasonably match up, that will be counted. That card will then count as a yes vote for the union. Okay? Remember that asterisk I mentioned to you earlier? Here's where it comes into play. Under PERC's rules, any employee who has signed a card, showing of interest card, can send PERC a letter asking that their card not be used for purposes of a cross-check. Okay? So, say you've signed a card, and 2 months later you find out that a petition has been started with PERC, and you think to yourself, wow, I really want this to go to vote because I no longer am sure which way I want to vote on this. You can send PERC a letter and we will not count your card for purposes of a cross-check. However, the showing of interest card still will be used for determining whether or not an election will occur. Okay? This is the one exception. I would also note the showing of interest card must also have a statement on it saying that employees have the right to withdraw their card for purposes of cross-check. We required that, I think, in 2008, and it's one of those rules that it trips up a lot of people, but the simplest explanation we can give to anyone is make sure you read what you're signing. Cannot stress that enough. Because a lot of these processes move fast. I cannot stress it enough. Read what you're signing and know your rights and pay attention. Because once the employer provides those signatures that I just mentioned a little bit ago, PERC will conduct the cross-check. So what this means is as soon as the employer gets us those records, we'll have the election. Actually, not an election, we'll conduct the cross-check. And then the results of that cross-check will be issued usually within 24 hours. Okay. The third possibility is a hearing. Okay. PERC will assign a hearing officer who will try and conduct a hearing to resolve the issues about the appropriateness of the unit or the eligibility challenges, and we try and do that within 30 days. PERC's executive director issues the decision in all representation proceedings. First time I did this presentation, I didn't qualify that with PERC's executive director, and people thought it was the executive director of this agency. No. It's our executive director. And we try and get those decisions out within 90 days. Now, if a hearing is ordered, a lot of the times employees in the bargaining unit are going to be, some, but not all, will be required to testify at that hearing to provide evidence. So, for example, if your position was challenged as either a supervisor or as a confidential, you're going to wind up having to testify at the hearing, okay? If the parties have disagreements about the appropriateness of the unit, we often don't need every single employee to testify, but what we do need are a good representative cross-section of the petitioned for unit. So whether or not you wind up having to testify or not will be entirely dependent upon whether or not the union or the employer calls you as a witness. All of the decisions of the executive director are appealable to the full commission, the PERC commission. So, let's go back to a situation here where, PERC has conducted the mail ballot election. Once the election has occurred, PERC will issue a tally of results, and those results will show what the tally of the election is. Now, the employer isn't required to post this in the workplace, so I often wind up telling people, if you have a question about what the results of the election are, just call PERC and we'll let you know. Similarly, where we conduct a cross-check, a tally of cross-check will be issued. And once a 1-week period after the tally of election or tally of cross-check has been issued, PERC will then issue a certification. And that certification will describe the bargaining unit, and it will say who won the election, or in the result of a cross-check, it'll certify the result. Now, the certification has an important role because it's one of the things that limits future elections. Where PERC has issued a certification, an election cannot happen for the same employees within 1 year, okay? And that's to provide stability to the workplace. You know, you don't want situations where every time one election occurs, people are going back and trying to undo that with another election. So we require a 1-year waiting period, and that's in the statute. The second limitation is what we call a contract bar. So let's say that you've selected union representation, the union negotiates a contract on your behalf, and then for whatever reasons are out there, you decide that you no longer want to be represented. Well, you just can't file at any time. Under 4180.080, employees are allowed to decertify their union in what is called a window period, okay? And that window period is between 120 and 90 days from the expiration of the collective bargaining agreement, okay? Almost every single state's collective bargaining agreement expires on June 30th of the even years. So these next, wait, do I have that right? No, I'm sorry, it's June 30th of the odd years. The agreements that are currently in effect right now will expire June 30th, 2013. So, counting back 120 days from June 30th opens the window period, and counting back 90 days from June 30th closes the window period. If you want an approximate guess, it's about the month of March, okay? But anytime during that period, employees can file a petition. Now, that doesn't mean that if they want to get rid of their union or change their bargaining representatives, they can't, get cards and other things in the period before that. It just means that window period is only limits the time for filing. So, with that, that's basically in a nutshell our general election process. Again, this is the process described here is pretty much the routine. There are variations and differences, but those are always dictated by what I'd probably call unique circumstances. And quite honestly, I never know when those are going to pop up. So I got about 20 minutes for questions. What I'm going to try and remember to do is, because this is being recorded, I'll be repeating your questions back to you so that the microphone picks them up, just to let you know. And so with that, I see one right here.
Me?
Yeah.
Oh, okay. Well, you can't revoke the showing of interest card. It must have a lifespan of the election year, is that correct? Or?
Correct. Correct. The question is while you cannot revoke a showing of interest card, the showing of interest card only has a particular lifespan. And correct, showing of interest cards must be dated from within 1 year of the filing of the petition. Okay? So it's all, the lifespan of the showing of interest card is dictated by the date on which the petition is filed. So, question? Question?
When it comes to the voting, the showing of interest card, is that saying I have an interest in voting on whether we have a union or not, or voting to have a union?
Okay.
And then a follow-on to that, when it comes to the voting, would all the employees in the agency be provided with ballots to be able to vote, or as when BIS came up, the only ones that were notified of the vote were those who already belonged to the union, so the rest were not notified of the vote?
Okay.
They were allowed to vote if they showed up, but they were not provided that information.
I'll try and break these up into chunks, and then if I miss something, we'll come back. The first question was about the showing of interest card, and her question was whether or not the showing of interest card can be used to prompt a vote, I believe.
It was, is a showing of interest card to say we want to vote whether we want to or not?
Okay.
Or was it to say we want to?
Okay. Her question was, does the showing of interest card have to say whether or not we want a union, want to vote on having a union, or does the showing of interest say you want a union? And the answer is the showing of interest card has to say you want a union. It cannot call for a vote. It has to be an affirmative statement desiring union representation. Okay? However, if we're going to mail ballot election, all because you signed the card saying you want an election if we do a mail ballot election, that doesn't mean you're not free to change your mind. Okay? So, you know, although they're not exactly the same, one of the things I often describe the showing of interest cards to is to a citizens initiative that are filed. You know, all because somebody signs their name to a petition form to, you know, do whatever citizens initiative is out there, doesn't mean that that controls your vote. Unless, however, as I mentioned earlier, the matter goes to a card check. And that's why we require the card to be an affirmative statement of desiring union representation. Because the card can be used for having a cross-check. Again, where a cross-check happens, no election occurs. That's why it has to be that affirmative statement. Okay. Did you had another question?
Well, that does raise the question then, if folks wanted to get the union out, would the petition be the same way?
Well,
That it's a vote to get the union out?
yeah, and that's why, again, you know, you make the card on the one hand, if you want union representation, then the card has to say, I affirmatively want Union X to be my bargaining representative. If employees desire to get rid of a union, the cards simply say, I no longer want Union X to be my exclusive bargaining representative. Or I want to decertify Union X as my exclusive bargaining representative. And it can be that simple. You know, we're not trying to hide the ball on the language of the cards.
So what determines when there's a mail ballot election and when you do the cross-check?
Okay. Again, the question was what determines when we do a mail ballot election and when we do the cross-check. And again, when we get the list of list of employees from the employer, and literally what we wind up doing is counting the number of total employees that are going to be in that petitioned for unit. If the union has submitted cards showing at least 50% of those employees want to be represented by the union, then we will go to a card check, cross-check. Okay? So it really depends on what, you know, how many employees are actually in the petition for unit. And I'll tell you something really interesting. Sometimes, and it's really interesting that the unions know better how many employees are in their petition for units than the employers do sometimes. It's never ceased to amaze me how well some bargaining representatives know what the composition of an employer's workforce looks like. Questions? Okay.
What you talked about, mailing ballots,
Mm-hmm.
if we have the mails, does that ballot come to us at work or do you mail it to our home?
We mail it to your, okay, the question is where do mail ballots go? And we mail all of our ballots to an employee's home, okay? And then the mail ballots are returned to PERC, not to the employer. So we keep the ballots and then we keep them under lock and key until the election's actually going to happen.
And this may be a silly question, but you keep referring to the employer. Who is the employer?
Okay, the question is,
Would it be what is, yeah.
the question is who is the employer? The way that PERC has treated employers for state government is we've done it by an individual, we've done it on an agency by agency basis. So if a case is filed involving employees of the Department of Enterprise Services, the employer of record listed on the case would be, we would do it as State-Enterprise Services. If it was Fish and Wildlife, we would do it State Fish and Wildlife. So we basically treat each individual agency as a separate employer. You know, for our other jurisdictions that we have, you know, the employers, the city of Olympia or Thurston County or city of Tacoma, it's a little, obviously it's a little bit different for the state, based just upon on the number of agencies. So that's how we decided to break up the state so we can identify which agencies we're talking about. Okay. Great.
So earlier in your presentation, you said that DES is unique and you've not been in this situation before. So even there are various, some people are represented in DES and some people aren't, and I think there are multiple unions. So what are the next steps?
The question is what are the next steps due to the unique circumstances creating the Department of Enterprise Services? And from our standpoint, from PERC's standpoint, we have not received any petitions from either the State Labor Relations Office or any union who represents employees who were represented from the former agencies. So I can't answer that question because we don't have anything before us. Once something is filed, it will go to our executive director, and the PERC executive director will need to make some determinations. But what those are, I can't speculate, and I don't even want to guess. Okay.
A few questions back, you said that you're the ones that mail it out to all of the employees that are affected and stuff. What do you use for the mailing address?
Okay.
Because, you know,
Yeah.
you get that.
Yeah. The question is how does PERC get the addresses for the mail ballot elections? And the simple answer is we asked the employer, probably your human resources office, for the most current address of record for each employee who's going to be voting in the election.
So do you ask for their legal address or do you ask for their name? Because sometimes if you ask for an address, they look at it and they get their legal, which some of us will never get.
Okay.
And then you have a mailing, which is different. So.
I've never thought of it in that context. I'm going to guess right now that we're using mailing address. But
It's something to think about.
yeah, it is something to think about. And
Because listening to, and her saying that they didn't get a chance, and if you're mailing it from your office, did she ever get it?
Oh, that wasn't the issue. It was that the union sent the ballot only to union employees, not sent to all the non-union employees, because the election was not handled through PERC. PERC said the petition is there, the election can be held, but it was the union that sent out the ballots, and they only sent it to representative employees, so nobody else got them. But if you found out about the election, you could go vote. They didn't stop you from voting. So it was kind of like almost against PERC.
so, okay, in the back.
So I'm not clear. Who will get notified? Only those that are showing a business card or all employees?
No, when PERC is going to conduct an election, we will be putting postings up in the employer's workplace. And what we strive to do is one posting per 10 employees who are going to be voting in an election. So if there's 100 employees who will be voting in an election, there should be at least postings in 10 different locations explaining to employees that an election is going to happen. This goes back again to make sure you're paying attention to what's going on in your workplace, and when something new is posted, make sure you read it. Because it will, when an election is going to happen, again, it will explain all of the conditions for the election, okay, including when ballots will be mailed, when ballots are due to be returned. It will also have it, actually no, that'll be part of the investigation statement. But the investigation statement will state who the eligible employees are, okay? So, you know, If you look, when we have the employer post the investigation statement, there'll be the list attached to it. You flip the list, and if your name's on it, you're going to be voting in that election.
What initiated this, I guess, information session? I mean, was it, if you didn't hear from the union or from the employees, was it, what initiated this?
My particular presentation was initiated by Terry Wilson, who's this agency's HR manager. She had contacted me and asked if I would, because DES has a lot of employees in areas, OFM and DOP, who were employees who were not eligible for collective bargaining where they were at. And now that they've been moved to enterprise services, they do have collective bargaining rights. And so she asked me to just give a basic presentation about PERC's processes, and I gave her a caveat. I don't know what's happening with some of the other things. I only control my little process in the world, so you have...
Yeah, I just had one point of clarification. When a list of eligible people are established and the vote happens, the ballots are mailed to that list of people, and say that there was an affirmative vote for representation, does that affect anybody outside of that eligible list?
No, okay. The question is when we're going to be doing an election, is whether or not the election affects any employee who is not on the list of eligible voters. And the answer is any employee who's not on the list of eligible voters is not affected by the election. Okay? Where we conduct an election, again, those 100, if it's 100 people who are going to be who are petitioned for in a proposed bargaining unit, it'll be those 100 people will be voting, and if they vote in favor, if a majority of the employees vote in favor, if the majority of the ballots cast vote in favor, then all 100 will be represented. Anybody who's outside will not be impacted, necessarily. But that's, the not necessarily is, I shouldn't have said that, but here's how one group of employees being represented could impact other employees. And that is, once a bargaining unit is certified, the work performed by that unit is bargaining unit work, okay? And no other employees who are not represented should be performing the work that the bargaining unit is certified to perform. And so that's how other employees may or may not be affected. Does that answer your question?
So along those same lines as that question, there's a time period between the ballots being cast and the certification happening. If a new employee comes on, do they get the chance to also vote, or do they get whatever the ballots cast?
No, they do not. Okay, once the cutoff date for eligibility to vote in the election is the investigation statement, okay? So, for example, if we conduct the investigation conference on January 1st, we generally issue the investigation statement the same day. And in order to be an eligible employee to vote in the election, you will have to be employed in the bargaining unit on the day of the investigation statement, so January 1st. Any employee who is to be hired on after does not get a vote. Similarly, any employee between the time of the investigation statement and the due date for ballots, if somebody quits, their vote drops down. Okay.
How about a phone number for PERC? I never saw one come up.
Oh, it's on the first page.
Oh, it is?
Yeah.
Oh, I see.
Back.
I just wanted to share some information. I sure want to
with that, I thank you for your attention. I know it's a little bit dense, but if you have any questions, please feel free to call. PERC is here to answer questions to the best of our abilities. So, thank you.
Thank you.